So in previous videos, what we did was take an introduction to the subject of dispute resolution for the SQE. And in addition to this, we spent some time talking about the different types of dispute resolution. Now, what is the case is that, of course, we're going to be spending the majority of our time focusing on a single type of dispute resolution, which is, of course, civil dispute resolution, which is, of course, civil litigation, that kind of stuff. But it is important that we spend some time talking about the other forms first. And the reason for that is because it is highly encouraged that parties to a dispute resolve said dispute through means and mechanisms that aren't litigation. And so the other forms of dispute resolution, such as arbitration and mediation, as cited here in the specification, are very important because they are highly encouraged before any kind of dispute arises. And so in the specification, we're going to talk about the different forms of dispute resolution. Specifically in this video, we're going to talk about the concept of mediation as an alternative dispute resolution. The next video, we will talk about arbitration, and then we will start thinking about litigation and some of the pre-action issues that need to be considered before somebody actually goes to the process of litigation. So things like limitation, things like a cause of action, things like the pre-action protocols, etc., etc., etc. And so in introduction here, we're just going to be spending some time in this video talking about the concept of mediation as an alternative method for dispute resolution. Very simple. Now, mediation is probably the least formal of these different types of dispute resolution that we are going to spend some time talking about. I know in previous videos I spent some time talking about negotiation. Negotiation isn't really included in the SQE specification. Very simply, negotiation is, as it says on the tin, it is just the negotiating between the disputing parties to come to some kind of resolution before formal procedures take place. Mediation, then, of the ones that are cited by the specification, mediation is the most informal of these different types of dispute settlement, alternative dispute settlement resolutions. One of the features of mediation is that it is a voluntary process. Nobody is necessarily compelled to enter into mediation where a dispute arises, although it might look particularly poor on your case if it is shown that you had the option to mediate such a dispute and you decided not to mediate such a dispute. Like I've said at the beginning, parties are heavily encouraged at various different stages, really at every single stage throughout the process of dispute resolution and throughout the process of civil litigation, to try and resolve this process without the need for having courts intervening, essentially. And that's because, of course, courts are very busy. Courts have to deal with lots of cases. Often dispute cases and civil cases can be quite long and complicated and quite costly. And so the courts want to encourage people to have to go down other routes rather than go down the routes of litigation. But that's one of the features of mediation, is that it is a voluntary process. The second part of mediation is it is a confidential process. The people who are involved in a dispute can consult a mediator in such a way as to try and confidentially resolve the matter. And this is where the idea of a mediation really gets its teeth, and this is the idea that mediation involves a neutral third party who will go in and who will look at the case, who will speak to the parties to the dispute and see if they cannot find some kind of amicable resolution to the dispute that satisfies both parties. This person is, of course, known as a mediator, and they are a neutral third party. So usually the mediation process will typically involve some kind of initial meeting whereby the mediator may meet with both parties. Often they will meet separately, of course, because it could be quite a sensitive issue. It might be quite a complicated issue. There might be quite a lot of bad faith and bad blood between the two parties if there is a dispute. But fundamentally, they might often separately meet with each of the parties as a way to understand the dispute needs of each of the parties, what is needed from both sides to reach some kind of amicable solution. Now, often, by very nature of the definition of a dispute, they meet both sides because both sides have different standards by which they believe it is necessary or it is satisfactory to come to an amicable conclusion. And so the result is that they have to look at who wants what, essentially, in a mediation, and how to arrive at that particular conclusion. There may also be meetings where both parties are together present. This might, in some circumstances, be particularly fruitful as a method by which the mediator can deal with such situations. Fundamentally, what mediation does is it encourages the meeting of the parties, often together, as a way to resolve the issue as quickly as possible, to resolve the issue quickly without any kind of costs to either of the parties, or any kind of substantial cost to either of the parties, and without the need to go down the road of formal litigation. As with all of these different types of dispute resolution, there are advantages and there are disadvantages. So in terms of the advantages, meetings in mediation are firstly confidential, and so discussions cannot be used in court if the dispute ever escalates to litigation. This is very beneficial because it essentially allows the parties to speak frankly without them fearing that they might have things said against them in court, or having these things brought up in court as a way to undermine their particular position. They can say whatever they want, they can say whatever they so choose, and this can often get to the crux of the issue quite quickly. And so this is a very important benefit of mediation as a primary stage before any kind of litigation. So if, for example, this mediation process does not become fruitful, turns out that the mediator just cannot square the circle and deal with this dispute, well, then it can come to a point where it escalates to litigation, and the parties don't have to worry about what is said in the process of mediation because this process is confidential. The participation in mediation, of course, is also voluntary, and the parties will control the outcome of that, which is, again, another really important thing that sets it apart from litigation, because in litigation, even no matter how strong a case you feel like you might have, who knows what the result might be? Who knows what the outcome might be? Court is very, very different to things like a mediation process. And so you want to lower the levels of risk that you are subjected to insofar as you possibly can. And so if you are able to control the outcome through a mediation process, you don't have to essentially subject yourself to the whims of the court, who may impose an outcome that you are not happy with. Even if they might rule in your favor, they might not rule in your favor on all the points, or they might not award the kind of damages that you were expecting. All of these things can factor into the desire to try and resolve the dispute through mediation rather than through litigation. A final point, or a further point, should I say, that of course mediation is very cost effective compared to litigation. If you have a dispute, you can get a mediator and they can resolve this dispute very, very quickly, and often in a lot of cases. If you want to litigate this issue, then this might involve quite a lot of expensive issues, a lot of expenses that are taken out that are not that might in fact cause you to cost more than the dispute is even worth. So that's another thing that has to be considered. Furthermore, mediation can preserve the relationship between the parties. Litigation will often involve a breaking down of the working or the commercial relationships of the particular businesses or of the particular parties. Nobody likes to be sued. Nobody likes to be involved in litigation. Nobody likes to be the claimants in litigation, nor do they like to be the defendants in litigation. And so this can really hamper the working relationships of some people if it ever comes to the issue of litigation. And then finally, a further advantage is that it is, of course, faster as a method of resolution than that of litigation. Depending on how complicated the case is, it could take months, maybe even years, for a case in civil litigation to actually be resolved, whereas, of course, through mediation, it is a lot easier, a lot quicker, a lot more simple. So those are the advantages, but what are the disadvantages? Well, the parties are able to leave the process whenever they so choose. So if they feel like they're just not getting anywhere, they can just walk out, which means that there is no guarantee of a resolution to the dispute. At least with litigation, you are going through the long, arduous process, you're going through lots of costs and all these different kinds of things, but you're at least particularly or pretty confident in the fact that you are going to resolve the matter one way or another when you get to the end. Of course, when you get to the end, theoretically, there could be an appeal, but once all the methods and all the sort of avenues for appeal have been exhausted, you know that you have finally exhausted all the issues and the dispute is officially resolved in one way or another. With mediation, the door is potentially open. You could resolve the dispute, or you might choose, or maybe decide, or the other party might decide that they don't want to resolve the dispute through mediation, that they're not getting anywhere, and so they go to a different stage. In some cases, you might find that one party dominates the process. So if there is a significant power imbalance between the claimant and the defendant, or vice versa, then this can lead to a situation in which you have a sort of David and Goliath process going on within the mediation procedure, and that can be quite damaging to the outcome of a particular dispute. If you're a normal, ordinary individual and you're trying to solve a dispute through mediation with a huge conglomerate, for example, then of course that is going to be a massive power imbalance that a mediator does not necessarily quell or quash in terms of that balance. A court is a lot better at balancing this kind of dominance in power than that of a mediator. And then finally, since there is a lack of disclosure when it comes to evidence, disputes may be resolved without fully understanding the facts. So there is no disclosure, there is no need to disclose all the information, all the evidence, as is the case when we think about litigation. But what this might do is it might mean that one party or another party decides not to disclose all of the facts, and then they come to a amicable conclusion on the basis of the limited number of facts that have been disclosed, which could then lead them to entering into a resolution that they would not have otherwise agreed to had they had access to all the evidence. Sometimes formal litigation procedures are beneficial for very simply the reason that they can give you quite a lot of disclosure. They can give you quite a lot of access to evidence that gives you a better picture of the dispute. So this is another disadvantage associated with mediation. Now, theoretically, if all the parties enter into the mediation process in good faith, then these disadvantages might be neutered in one way or another. They might, if they're entering into good faith, the power balance might not be so pronounced. The disclosure of evidence might not be so sneaky, for example. And so it really depends on who you are looking to mediate a dispute with, and the process in which, and the type of case that you are looking to examine.